challan cases, and also in the cases of 138 cases, 138 NI Act cases. Thereafter, the Honorable Supreme Court has given certain directions, certain guidelines, how the states-wise high courts has formulated. There are certain guidelines for the digital trials, stops, and all those made the arrangements. In the same line, the Honorable Supreme Court in the year 2020, in the matter of Makwana Mangaldas Tulsidas versus State of Gujarat, in 5th March 2020, also has given certain guidelines that there should be some digital courts to be constituted, and how the digital court will be functioning. There are the certain guidelines in this matter has been framed. Thereafter, the Honorable Chief Justice of Delhi High Court has formulated the guide because approximately Mansi Mansingh, I will request to please mute because there is an echo in the sound. Thank you. In the Honorable Chief Justice D.N. Patel of Chief Justice of Honorable High Court has felt necessity, because he has felt that in 2018 and 19 there are the more than 2 lakhs of cases of 138 has been pending in 2020 itself. Therefore, there was a SOP has been constituted by the Registrar General of the Delhi High Court, and initially there were 34 courts has been constituted for the digital trials, and it was effective from 17th November 2020. All the digital courts, all the cases trials under Section 138 of NI Act of Dishonour of the Cheque started digital trials from 17th November 2020. Therefore, friends, these are the background. What was the necessity and how it has been started, the digital trials, and what was the necessity to start the digital courts. Then we come on the check, dishonour of the check. Once the check has been dishonoured, then what is the procedure and how the court will proceed and how the process will go on and thereafter. First of all, you have to decide, once certain person has given the check, and of course it has to be against the liability, then check has been dishonoured. And once the check has been presented and it has been dishonoured, maybe the reason of the anything, because maybe the reason of insufficient fund, maybe the reason of the blockage of the account, maybe reason of the exceeds arrangement, there are the certain reasons given in the format of the banks. If the check has been dishonoured, then first of all, what you have to do, being a professional, if the certain people approach you that yes, my advocate, this check has been dishonoured, please do the needful, how we can take the amount from the another person. Then the person will approach you. Then how to proceed, I will come into that. And how, first of all, there is a Section 138 of Negotiable Instrument Act, and in that section there are certain provisions has been given. Once the check has been dishonoured, then there is a statutory requirement to serve the legal notice within 30 days from the date of the dishonour of check. How the 30 days will be calculated? 30 days will be calculated once you have received the memo, bank memo from the bank. The day we receive the bank memo, you have to serve the notice within 30 days from the date of the receiving of the bank memo. If it is not within 30 days, then everything is gone. You have to present the check again. Therefore, you have to be very cautious about the time period, that once you have received the dishonour of the check, bank memo, you have to serve the notice within 30 days from the receiving of the bank memo. Once you have served the notice, and while the serving, what is the necessary requirement, I would like to share the legal notice, how to draft a legal notice. Only So first of all, once you are serving the legal notice, then the legal notice has to be on the legal letterhead. Kindly, I will share the notice so that it will be easy to understand all those things. This is the format of the legal notice. Friends, it has to be, first of all, it has to be on the letterhead. And letterhead contains your address, email ID, mobile number, and all those things. And thereafter, you have to write on the top that it has to be sent through courier, through speed post, through WhatsApp, or through email. Nowadays, it is prevalent practice that you can serve the notice through email and WhatsApp. Thereafter, you have to mention the date. You should not forget the date on which you will serve the notice. That is very mandatorily required. Once you will forget the date, that is very difficult to justify yourself in the court. Then the name of the accused to whom you are serving, his name, his address, his telephone number, and his email ID. All those things should be necessarily mentioned in this legal notice. Once there are the two addresses of the particular person, then you have to mention another address also at address number 2. Once you are serving the legal notice to the company, then you have to take the registered office address from the master data of the MCA. Ministry of Corporate Affairs, in the case of the company, their master data has been maintained. From that master data, you have to serve the notice on the registered office and through his email. And apart from that, you can also go through the master data, who are the directors of the company. You can also serve the notice to all those directors, may not be the party later on, but it is a standard practice to pressurize the client that you should make a party to all the directors of the company who is mentioned in the MCA website. Otherwise, it is mandatory to serve the notice the person who has signed the check. It is mandatory because the person who has signed the check is especially responsible, whether he may be the director, may not be the director, he may be the authorized signatory, but once he has signed the check, he is responsible for all those checks. So keep in mind to whom you have to serve the notice. Maybe if it is individual, then to the individual. If it is company, then the company as well as his directors. Once the director is not signatory of the check, the person who has signed the check, these may be the party. Of that, once you are serving the legal notice, you have to be very necessary keep in mind. You should not forget it. Then you will come on the subject matter, that legal notice under section 138 of Negotiable Instrument Act as amended up to date. Then you will say the name of your client. What is the name of your client and what is the address of your client? You have to mention. Then under instruction from on behalf of our client so and so, that you are serving the notice on your client. Then you will come on the topic that what is your client business, then what the accused is doing, you should mention. Thereafter, because once the check has been issued, it has to be against the liability. Once there is no liability, then there is no section 138 NI being attracted. You have to prove in the court that yes, whatever the check has been issued by the accused, that check has been issued against the liability. It is very mandatorily required to prove yourself. Therefore, once you are serving the notice, you have to keep in mind that whatever the check has been issued, it has been issued against there are the certain liabilities. You have to mention in your legal notice that this check has been issued against this liability. And once he has issued the check, you have to very clearly mention the check number. Suppose if it is 2134, then it has to be very clear 2134. It cannot be 2135 or 2136. So it is very cautiously, you should not make a mistake. What is the check number and what is the amount in words and figure both, and what is the date of the check and drawn on the bank. These 3-4 information you have to be very accurately mentioned. Once you make a mistake, then your entire case is becoming infructuous and you will not win the case. Therefore, you should be very cautious while writing. That should be check number should be very clearly mentioned. Date of the check and what is the amount of the on check and drawn on this bank. It has to be very clearly mentioned. And once you have presented the check, then you have also mentioned where you have presented your check, to whom, what is your name, bank name, because on the basis of that branch, your case is going to be entertained on the basis of that branch where you have presented the check. Jurisdiction issue will be invoked. And you have to also mention that for what reason that check has been dishonored. This is maybe in the fund insufficient, maybe the exceeds arrangement, or maybe the account blocked. There may be the different reasons for dishonor of the check. Then you have to specifically mention that yes, due to this reason, the check has been dishonored. And what is the date of the bank memo? This fund insufficient, bad bankers memo dated so and so, so and so. You should not forget to write the date on the bank memo, because once from the date of the bank memo, 30 days will be calculated. Therefore, it is necessary to mention that what is the date of the bank memo. Thereafter, you have to write that even after the dishonor of the check, you have apprised you and also tried to contact you to serve the notice and to also apprise about the dishonor of the check. And even though after knowing the fact that this check has been dishonored, you have not made the payment. Therefore, by virtue of the present legal notice, you are serving the legal notice demanding the amount. Again, you have to be very specific. Amount has to be clearly mentioned. Whatever the amount mentioned on the check, you have to mention that particular amount only, not more, not less. Therefore, you should be very careful while serving the notice. That amount should be very clearly mentioned, and whatever the amount mentioned on the check only. And another provision that it has to be statutorily required that you have to mention the time period is 15 days. You cannot say 14 days, you cannot say 20 days, but you have to write that with client within a period of 15 days, because it is a statutory provision under section 138 that once you serve the notice, then within 15 days from the date of the receiving of the legal notice, he has to pay that amount. So this 15 days is also very much important. So all these things, whatever I have discussed, that is very necessarily required to mention. You should not forget anything. The check amount, date of the check, amount on the check, and drawn on which bank, and check number. And it has to be pay the amount within 15 days. These all are the statutory requirements. Within 15 days, you have to make the payment. And at last, that once you are serving, suppose I am the partner of Nux and Partners serving the legal notice, then at the last, Nux and Partners and name of the advocate and enrollment number. And thereafter, it has to be properly signed. In the last session, we have also discussed how to draft a notice. It has to be properly signed. Once you have not signed this legal notice, then it is also very difficult situation to prove your case. Your legal notice not be entertained. It is not legally and valid legal notice. Once you have not served the legal notice, then 138 case is not maintainable. It is a statutory requirement that before filing a case under section 138 NI Act, you have to serve the legal notice, that is a statutory legal notice. Once you have not served the statutory legal notice, then your case is not maintainable. Keep in mind. And even though you have served the legal notice, but your legal notice is not duly signed, then it is no legal notice at all. So always keep in mind that it has to be properly signed. And once you are sending the legal notice, it may be sent through WhatsApp, maybe through speed post, maybe through courier. And once it has been delivered, you should also take a copy of the delivery report, because once you will file a complaint under section 138, you have to place on record that whether your notice has been delivered or not delivered. It is one of the also mandatory requirement. So once you have served the notice through speed post or courier or email, that you should take a printout of that, whether it has been delivered or not delivered. So this all about the legal notice. Once you have served the legal notice, then you have to wait for the 15 days from the date of delivery. From the date of delivery, 15 days you have to wait. Once he has not paid the amount within 15 days, then you can file a complaint. before the court. Once the 15 days has been expired, then you can file a complaint before the honorable court. And then how to prepare a complaint and what are the necessary requirements to file a complaint. I will share with you how to draft a complaint. First of all, before drafting a complaint, you have to decide the jurisdiction. Wherever your cases lie, what is the jurisdiction to file a complaint? This is the most important issue, has to be decided. Because once you have filed a case where there is no jurisdiction, then your case will be dismissed maybe later on. Otherwise, nowadays there is a practice of the digital court. Then once you have filed a case in somewhere and it is not maintainable in that particular jurisdiction, then it will be not listed before the court, and whoever is looking after the matter, he will certainly suggest you that this case is not maintainable here, you can file somewhere else within the jurisdiction of the someone else. So all those jurisdictions, how to decide the jurisdictions, where he has to file a complaint. Once you have presented the check, and wherever you have presented the check, and wherever is your base branch in the sense, suppose I am having my account in ICICI Bank, and I have opened my ICICI Bank in the Lajpat Nagar, even though I am resides in the West Patel Nagar, but I have opened my account in the Lajpat Nagar ICICI branch. Then if any check, suppose I presented the check in Patel Nagar in the ICICI branch, we can present the check anywhere in India. But for filing the complaint under section 138, wherever is your base branch, wherever you have opened your account in the bank, that will be considered for the filing of complaint. Suppose my check has been dishonored, I presented the check in ICICI Bank Patel Nagar, and that check has been dishonored. Therefore, I have to file a complaint in the Saket court because my base branch of the ICICI Bank is the Lajpat Nagar. So you have to keep in mind, and you should ask your client that where you have opened your account, and wherever he has opened an account, accordingly you should decide under which police station jurisdictions that base branch is falling. Therefore, you have to decide the jurisdictions where it may be go. And once you have started the drafting, then you have to write the name of the Chief Metropolitan Magistrate, maybe in any other court, maybe Rohini, T. Sajari, or maybe because the case had, this case, 138 case has the original jurisdiction, irrespective of the amount. It may be 10 crore, 20 crore, 100 crores, check dishonored, but it is all within the jurisdiction of the district courts only, not in the High Court. So in section 138 NI Act, it is the original jurisdiction. District courts have the original jurisdictions. Then complaint case number, and case number should be of year in which you are filing the case. Suppose you are filing the case in 2023, then the complaint case number of 2023. If it is filing in 2022, then 2022, 2024, then 2024. Accordingly, then you have to mention the name of the party, who is the complainant. Then, because you cannot, suppose if it is in civil nature, we can make it two complainants in the party. But suppose I am Nityanand Singh, my wife's check has also dishonored, my check has also dishonored. Then we cannot file a single case on behalf of my check and my wife's check. This is also a very important point to be noted. You have to file a separate case for each party in the complainant. Suppose if you are filing a civil nature case, then you can file a single case on behalf of myself and on behalf of my wife. But in under section 138 complaint, you have to file a separate case. Suppose if my check has been dishonored, then I will file a separate case, and my wife's check has been dishonored, then my wife will file a separate case. Both cannot be party in the same complaint. This is also very important point to be noted. And person who has issued the check, that will be the party. Suppose if the company is issuing the check, then only company has to be made a party. Company as well as his director will be a party. Maybe 1, 2, 3, whoever the director, because the person who is taking care of or looking after the day-to-day affairs of the company, he has to be party. And in the cases, we also suggest that to pressurize the opposite party accused to make a party to all the directors of the company. May be possible that it may be the one or two party may be deleted, but it is one of the pressure tactics. It may be possible, and also make a party to the person who has signed the check. This is also very important. It may be the director of the company, may not be the director of the company, maybe the authorized signatory, but the person who has signed the check is responsible personally. Then accused, then who is the PS, wherever is the police station, you should mention police station. Then you should prepare an index. Thereafter, memo of party, that is a very important point. The memo of party, complainant and accused persons. This memo of party decides the jurisdictions as well. So you should be very cautious about this memo of party. Then complaint under section 138, read with section 142 of Negotiable Instrument Act. 142 says that the cognizance can be taken by the court, who is the competent person to take the cognizance of cases under section 138 NI Act. Then what the complainant is doing? If the complainant is a company, then you have to file a case through the authorized signatory of the company. Then you should make a board decision that yes, Mr. So and so is the authorized signatory of the company. Then you should draft a complaint accordingly, and you should also place on record the board decision. Then you have to properly written that yes, Mr. So and so has issued the check against the liability. Whatever you have drafted in the legal notice, that should be copy paste here. But you should not mention our client, but here has to be mentioned complainant and accused. In the legal notice, you have mentioned our client. You should not make a mistake, because in certain times, people make mistakes that got copy from the legal notice and also here written our client. This is not a good practice. You should also complainant, you should write either complainant or accused, not our client. And once the check has been issued, the check number should be very clearly mentioned. Check number, date, and amount are drawn on, and reason has to be given on what ground and by what reason, and it has been dishonored. If the checks are more than the one checks, suppose there are 2-3 checks has been dishonored of your client, then you can file a single complaint as well. You can file a separate complaint as well. So most of in the cases, we also suggest our client, if there are the 3 checks has been dishonored, then you should file a 3 different complaints. Reason behind that once there is a 3 complaints, then there are the 3 trial he has to be faced and 3 surety he has to come with. I will also go on how to surety has to be provided. He has to take bail thrice. So also suggested that you should file a separate complaint to pressurize the client so that we can recover the amount. And once you are drafting the complaint, check number, date, amount, return memo, reasoning of this honor check, it should be very clearly mentioned in the column like this, so that it will be easy to read to the honorable judges. Once all those reasons has been given, check has been dishonored, then what is the jurisdiction? Jurisdiction point. This honorable court has a jurisdiction. Then cause of action. That the cause of action has been arises on so and so dated, this reason, and thereafter the honorable court has a jurisdiction. Thereafter this complaint is filed within the time limitation, and last that this against this check there is no similar complaint has been filed or pending in any other court. All those provisions have to be mentioned in your complaint. Thereafter the prayer. In the prayer, simply say, you will say issue summons and punished to the accused, pass in any other directions. And nowadays, section 143A, I will discuss in detail that interim compensation will be granted to the complainant. And then once the complaint is over, then it has to be always be supported by an affidavit. You have to file an affidavit, and once supported with the affidavit, then list of the witnesses to whom you want to come in the witness box. Who is your witness? Whatever you want to prove, then you have to produce the list of the witnesses at the time of the filing of the complaint. Complainant through his proprietor, manager, officer, clerk of the bankers of the accused. If you want to bring the bankers on as a witness box to prove something, then you can ask the banker to come. And once you are serving the notice, then you can also ask the concerned officer from the post office to come and prove that yes, this legal notice has been delivered, or any other witnesses. You can call any other witnesses. Thereafter, list of the documents, whatever the documents you have placed on record, and pre-summoning evidence. Thereafter, you will come on the pre-summoning evidence. You have to file a complaint along with the pre-summoning evidence. This is evidence by your affidavit on behalf of the complainant. Whatever you have drafted the complaint, you cut and copy all the exactly copy. And I say, you have to start with I say, and everything is same. In the complaint, you can mark at an excerpt, but here you have to exhibit all those documents. The filing of the evidence is required because of you have to exhibit all those documents, and whatever the documents you have exhibited, that can be read as evidence. Once those documents which has not been exhibited, that documents cannot be read as an evidence. So you should be very cautious, very keep in mind that whatever the document you want to produce and whatever the document you want that the Honorable Court should read, you have to exhibit those documents. It has to be in original or maybe the certified copy. Photocopy documents are not allowed to be exhibited. So always keep in mind. Once you are anything placing on record, which is the computer copy, then you have to also support your evidence along with the 65B evidence, 65B of Evidence Act. That affidavit you have to also be filed.
इलेक्ट्रॉनिक रिकॉर्ड के लिए लगाया जाता है.
Legal notice. Legal notice. You have to file legal notice, check, banker's memo, delivery report. These are the mandatory requirements. Apart from that, if you want to file anything else, you can also file, but you have to exhibit all those documents, like exhibit CW 1/3. If it is more than one document, what is the meaning of the COLI? If it is more than one document, we are exhibiting in a single exhibit, then you can say at a COLI. Collectively, COLI means collectively. Once you have filed the complaint, you have prepared the complaint, list of documents, list of witnesses, evidence by way of affidavit, pre-summoning evidence. Along with that, you have to also prepare the wakalatnama. And that wakalatnama has to be duly signed by your client, and that wakalatnama has to be signed by you as well. So this is all about the complaint. And once you are filing the complaint, then there are the two necessary requirements for the digital court. The first is case information system. This is the format of the case information system. Kindly see. This is the case information system format. This is the first page of the complaint. Whatever the district, civil or criminal, you have to tick accordingly. Name of the plaintiff, complainant, son, wife, address, and all those things. Whatever is the necessary thing required, you have to fill these forms and place on record. Apart from that, this is the case information system. Then you will come on metadata form. That is also mandatory nowadays. Once you are filing the case through digital courts. Kindly see, this is the metadata form, NI Act complaint metadata form. This metadata form is mandatory. Once you have not filed, then your case will be under objections and you have to file it again. All those informations are required: mobile number, gender, name, parentage, email ID, status, address, everything is required. And whatever the requirement, I will not go into the detail. Then whatever the requirement, you have to fill that form, metadata form. And now your complaint is ready. Now your complaint is ready. Then I will show, once your complaint is ready, then you have to prepare a PDF format. PDF format with bookmarking and optical character recognition, OCR. There are the two requirements for filing in the digital courts. Whatever the documents you have prepared, all those documents you have to scan it and scan through bookmarking. I will show how the bookmarking can be done. Like, kindly see. This is the document. This is the document. Don't go on the title and all those things. But I'm just only showing how the bookmarking. What is the relevancy of the bookmarking? Like, as kindly see. Once there is a bookmarking, then index will be clear. Then affidavit. Once you will click on the affidavit, then directly go on the affidavit. And once you will click on the annexure, then will directly go on the annexure. Annexure 1, annexure 2, annexure 3. This is the bookmarking system. So once you are preparing the document, scan it, complete it with the bookmarking system and OCR. This is mandatory form. Without this, you cannot file the form. Now I will discuss how to file a form. You will go like this. I will just giving an example. E-code filing, E-code e-filing. You will go on the E-code e-filing. Then here you will log in. I am explaining each and every minute details. Then you will go on the here in Delhi. Register yourself. How to register? You will click here on the register. Then you will register. Login ID and password will be created. Once the login ID and password will be created, then I am showing it. Then you enter on the login and password. Yes, please. Anyone want to ask something? They will go and log in. Then you will fill the password. Then CAPTCHA. It will be open. Yes. Now, once you will login ID and giving the password, then this will be open. And once you are filing the case, your complaint is ready in all respect with the bookmarking and OCR. Then you will come on here in new case. You will select all those things. Select states, districts, court establishment, civil, criminal, all those things. Just I'm giving an example. Like I select Delhi district, any district maybe northeast, whatever the court establishment, maybe Chief Metropolitan Magistrate, criminal matter, appeal, original case type. Case type is complaint. NIA. In the MSCT matter, no. Matter urgent, maybe you can urgent or ordinary. Then you will further proceed. Then this information is required. Suppose you name of the petitioner, because once you will go in the details, certainly it will take much more time. So I'm only explaining the relevant things. You have to put the name of the petitioner. You will put the name of the petitioner in the organization. Then here all those things. Then you will go for the respondent name or whoever the name of the respondent. If it is the respondent is more than two respondents or more than one respondent, more than one accused. Suppose if the company is the party and there are another 2-3 directors are the party, then you can go on the extra information and you can fill all those information. and also go for the extra party. Once you will go for the extra party, then you can save all those information. Once you will save, then it will go on the next. Then case details. What are the case details? Case detail means case under section 138 NI Act. And what is the act and sections? 138 NI Act. What is the police station? You have to mention the police station. Then whatever the documents you have prepared, you have to upload those documents. And once you have to pay the fee, court fee under section 138, it is a matter of only 2 rupees you have to pay on the complaint, the only 2 rupees. And then you have to pay the court fee, and then it is affirmed, and then view, and at the last you will submit this. This complaint is submitted to the honorable court. Now you will come on the point, then once your complaint is submitted to the court, then how will proceed? Then you will come on the procedure. Digital court procedure. How the court will move? Once you have filed a complaint, these are, you have already discussed about the drafting of the complaints, preparation, attachment, filing. We have already discussed filing of the complaint with NI Act. Then cognizance and hearing before the digital trial courts. We will come on that issue because you have to cover entire things within that particular time. Once you have filed the complaint, one number has been alerted to you, and as per this number, your case is listed before the honorable court. And date fix, you have already have a link. Suppose if it is listed with some certain honorable judges, you can go on the website of that particular court, and you will find that this judge and link. And once your matter is listed on that particular day, that link will working, and you will click on the link. That on the very first hearing, on the assigned date, the physical file is placed before the magistrate. On the appearance of the complainant, magistrate hear the matters and take cognizance and issue summons. In some courts, there is also further tendering of the documents, but nowadays in the digital court practice, that the digital court will hear your matter and issue the summons without having the hard copy. Once the summons will be issued, then you can place on record the hard copy. This is the procedure nowadays. Once the summons has been issued, then you have to file the process fee. Probably some of my learned friend is aware about this process fee, and some of my learned friend may not be aware. Then I will tell you what is the process fee. Process fee, that is a format, that is a form of the process fee. You have to fill those forms, you have to affix certain tickets, and along with this process fee, you have to file a complaint, copy of the complaint. And also you have to, once the court has directed you to serve the notice through speed post, then you have to prepare envelope and place on record all those documents. Place within the envelope all those documents which you want to serve. Then go to the post office and weigh it. What is the weight? According to the weight, you have to affix the ticket. Affix the ticket and write the address of the accused person and the name of the court in the left hand side, and hand it over to the Ahmed. This is the process fee, how to file a process fee. Once the process fee will be filed, then it will be served to the accused person. And you can also take a direction from the honorable court that the complainant with the liberty to may serve to the accused person through email or through WhatsApp. Then you can also serve the notice to summons. Serve the summons. You can take a summons from the Ahmed and serve through email as well as WhatsApp. Preparation of the summons. The Ahmed will prepare the summons, and he will also directly send summons to the accused, and sometimes the court will direct you that he will issue summons to you, and you can also serve the summons to the accused persons. This is all about the service, how to serve the summons to the accused persons. For appearance of the once the notice has been, means summons has been served, then the accused will appear or not appear. It may be once after receiving the summons, certain times accused appear, certain times accused not appear. Once the accused is appearing, appearance of the accused in the court, accused persons appears in persons, appearance through video conferencing. This is one of the things of this digital trial court, that you need not, accused need not to go, or complainant need not to go to the court, because it is saving the traveling times. Suppose I am here and appearing before the court. Of course, in my office, there is no need to travel. It is saving of the money, saving of the time as well. In the courts, hardly it is a matter of the 5-7 minutes, not more than that. Whatever you want to say, you can say in the 5-7 minutes. But to say 5-7 minutes, you have to travel at least an hour. It may be more than an hour. It may be 2 hours. Suppose I'm practically, whatever I feel, suppose I want to appear before the Honorable High Court at Chandigarh, and you have to travel at least 6 hours in the morning. Then you can appear before the Honorable Chandigarh High Court. Otherwise, if it is through digital mode, of course, we can appear before the Chandigarh High Court or anywhere in India or anywhere in the world itself, you can say, from your office. This is the advantage of the digital court. You need not to travel. It is saving time, money, and everything. And accused need sometimes accused take a advantage that accused is not well, therefore he is not appearing, and he is out of his stations. Some accused person may take the advantage once he is appearing before the physical court. But nowadays in the digital court, no one take an excuse that he is not well, or he is out of his station, or he is somewhere else. So this is an advantage of this digital trial court, that the accused has to be appear before the court. He may be anywhere, because they cannot take the advantage of this, that I am not well or I am in out of his station. He can join from anywhere. Once the accused has joined, then the accused who is in the if the accused in the judicial custody or in the jail, then the production warrant may be issued against that accused person, and that accused persons can also join in digital courts through jail itself. Magistrate asks for once the accused will appear, then he have to furnish a bail bond. Then I will explain what is the process of the furnishing of the bail bond. You have to fill the form. That is also a format of the bail bond. You have to fill that format of the bail bond. One person will be surety. In the first portion of the bail bond, what is the name of the accused person, and the second portion is the name of the person who is giving the surety. And in the back side of that form, there is an affidavit given by the surety. And in the surety bond, you have to give certain amounts, like you can also place on record FD. Maybe the surety amount may be 10,000, 20,000, 50,000, whatever the amount will be given by the honorable court. What the amount, you have to fill that amount in that bond, and you have to furnish that bond. And in the digital court, you can submit it through digitally. You can send it through mail. And once through send it mail, it is accepted. Once accepted, then you have to file a hard copy as well. You have to place on record your thumb impressions in the copy of the maintained by the court, maybe the Halman, and thereafter you have to place on record the hard copy. Send it through soft copy first, then you can go, and whenever you want to go, you can go and file it a hard copy. This is the process for furnishing of the bail bond. Once you are appearing before the court, you have to furnish the bail bond. And once you have not received the copy of the complaint, then you can ask, yes, my lord, we didn't receive the copy of the complaint. Then the copy of the complaint will be supplied to you. Take the copy, go through the complaint, and then on the next date of the hearing, come prepared that the notice will be framed. What is the procedure for the framing of the notice? The honorable judge will ask you what you have offense have been committed. There are a certain notice before framing and notice. The honorable judge will say, yes, this is the case against you, that you have issued the check of rupees so and so, and that check has been dishonored, and even after serving the legal notice, you have not paid the amount. This is the case against you, because honorable judge will explain you all those things, and then ask bill questions. If you want to say something, you can say whether you have issued the check or not issued the check, or if it is not issued, then what is your defense. In the most of the cases, accused never say that this check has been issued, and being an advocate, you should suggest our client, once you are appearing on behalf of the accused, once you have admitted the amount that yes, I have issued the check and that check has been issued against liability, the moment you have admitted your liability, your case is over. You have to pay the amount immediately. In my personal experience, it says that sometimes the learned advocates didn't say anything to the accused, and sometimes accused admitted your liability, said truth, then immediately case is over. But once the accused is going for the framing of the notice, being an advocate, it is our primary responsibility and duty to suggest your client that yes, you should never say that it has been issued by me, and you should never admitted your liability. You should simply say this check has been issued against the security checks, and you have only signed the check, you have not filled the amount, and you have not filled the date and detail, all those things. This is standard practice to save our client, because it is our primary duty and responsibility to save our client. Once the notice has been framed against you, certainly you will not admit, then the matter will go for the trial. Once you have not admitted and claiming the trial, you do not plead guilty and claiming the trial, then certainly one the mandatory requirement that the court will ask you that you have moved an application under section 145(2) of Negotiable Instrument Act, taking your defense that we want to examine the complainant. Complainant has not with the clean hands, and he has misguided to the honorable court, and he has presented the false and fabricated facts. Therefore, this case has been this summons has been issued to the accused. Therefore, I want to cross-examine the complainant. 145(2) application normally is being allowed. 145(2) application has been allowed. Then you can cross-examine the complainant. And once there is a notice has been framed against the accused persons, then the complainant can file an application under section 143. This amendment came into the force on 2018. 1st September 2018, section 143A under the Negotiable Instrument Act, that for the provision of the interim compensation. That interim compensation may be awarded by the honorable court of 20% of the check amount. That is, the 20% is the maximum amount. It may from 10%, 20%, whatever amount, it may be 20%, but cannot be more than 20%. If anyone asks for the interim compensation, then certainly they can move an application for interim compensation. So this is the process. You can file an interim application for the interim compensation, and once you will file an application, the opposite party will file the reply, and then matter will be argued. And honorable court may allow, may not be allowed. It is a discretionary power, because section 143A says the word may. Just I will read it, that notwithstanding anything contained in the Code of the Criminal Procedure 1970, the court trying an offence under section 138 may order the drawer of the check to pay interim compensation to the complainant. The word may is being used, and it is a discretionary power vested with the learned magistrate. And the Honorable High Court of Delhi and also another High Court has clarified when the discretion can be used, under which circumstances discretion can be used. LGR Enterprises is the latest judgment, that in which what are the terms and conditions, under which circumstances, that is not exhaustive but inclusive, under which circumstances this power can be exercised. LGR Enterprises judgment, my learned friend can go through. Thereafter, once we are cross-examining the complainant, then the complainant cross-examination is over. Then we can record the statement of the accused. The matter is fixed for the recording of the statement of the accused, that is SA. You can say in the simple word SA. Once the statement is being recorded of the accused, certainly the honorable judge will ask the question from the accused. Yes, Mr. Accused persons, tell me why this check has been dishonored, why you have not made the payment, whether you have received the legal notice or not received the legal notice, All those questions will be asked by the honorable judges. Then the accused will say yes or no, whatever the answer would be. And once the essay has been completed, then the matter go further. These all are the proceedings are going through the digitally. You are joining the court from your office itself. And once the notice has been framed, how then the question arises how that accused will sign those documents. Then the whoever the reader of that particular court, reader will send the notice to the either maybe the email ID of the learned counsel or maybe the email ID of the accused. They will send the notice, and once you will sign that notice and again send to the court, and court will place it on record. In the same manner, but in the nowadays the practice is while the cross-examination, the complainant can be cross-examination physically. You have to appear before the court physically during 2 times in the cross-examination of the complainant and for the cross-examination of the accused. These 2 times you have to appear in physical mode, not in the digital mode. And apart from that, you can appear through the digital mode. And thereafter, the position comes for the defense evidence. The person will lead the defense evidence, but the Honorable Supreme Court says that you can lead the evidence not in the writing, but orally. Accused cannot give evidence on affidavit, as has been held by the Supreme Court in Madhvi Coop Bank versus Nimesh Thakur 2010 SCC. Once you are giving the accused or accused defense or accused evidence, then it cannot be in the writing. It has to be on the orally. Whatever the accused will say, that has to be recorded on that particular place immediately. And whatever the document you want to produce before the court on your defense, you have to produce those documents immediately, and you have to exhibit all those documents on the time of the defense evidence. You cannot place on record the defense evidence documents earlier. So this is the process. Then once the complainant evidence is over, essay is over, accused evidence is over, then the matter is placed for the final argument, and both the counsel will argue the matter. And meanwhile, arguing the matter, you can also place on record your written arguments. Whatever the judgments you want to cite, you can place on record all those judgments. All those judgments, once the argument is over, then the matter is fixed for the reserved for order. The order will pass by the Honorable Court, and once it is fixed for the judgment and sentence, once the judgment has been passed on, if it is in conviction, then the date may be fixed. You can join through online in the judgment, and once there is a conviction, then what is the sentence, then the matter may be fixed for the argument on the sentence. Once there is a conviction, then of course we have to argue on the sentence. What would be the punishment? That is in the section 138, and that is the maximum of the 2 years, not more than that. That is maximum punishment is 2 years, or double the amount, or maybe both, 2 years imprisonment as well as double the amount of the check. Then once we have to argue the matter on the sentence, whatever the sentence may be decided, that is maximum 2 years, maybe 2 months, 3 months, 4 months, 6 months, whatever the court has made deemed fit, he can award the sentence. Once the sentence is awarded, then suspension of the sentence, you have to file a form that yes, whatever the time period is required, 1 month time will be given to you, that you can file an appeal. You have to file a form that yes, accused e-file application for the suspension of sentence in the matter of the provided miscellaneous applications. And once you will file a form, the accused may be go for the sentence, or it may be possible that when the court will pass an order, it may pass an acquittal of the accused. There are the 2 possibilities, maybe acquittal, maybe sentence. Once there is acquittal, then also you have to file certain forms. That form is required that yes, when the other party will file an appeal within a month, then you have to appear before the right court, that you are giving a guarantee that yes, I will appear before the appellate court. Then once you will come, this matter is everything is over. In between, there are the 2-3 possibilities. Also, there are 2-3 possibilities that matter may be referred for the mediation. Once the matter is, any party can request for the mediation, either maybe the complainant, either maybe the accused. Once the complainant or accused refer for the mediation, then the matter will be referred for the mediation by the Honorable Court. And once there is a matter is settled before the Honorable Court, then the statement of the accused will be recorded as per the Dayavati judgment of the Honorable High Court. If there is a mediation, digital mediation proceedings shall be forwarded. In case of the settlement, the magistrate, after receiving the mediation communications, fix a date for the recording of a statement and undertaking of both the parties in terms of division bench judgment in Dayavati versus Yogesh Kumar Gosai, 2017, SSC online. In this, according to this judgment, once you have settled the matter as per this judgment, once, even though you have not paid the amount, that the decree will be passed against you. Therefore, a statement is recorded that yes, this matter, whatever earlier the person go on the mediation and settle the matter before this judgment, and ever after settlement they didn't pay the amount, then what was the option vested with the learned MM, that yes, even though he didn't pay the amount, then we will proceed further and start trial again. But after this judgment, there is no trial. Once you have admitted your liability, accepted that I will pay that amount, then you have to pay that amount. And once you will not pay that amount, then the decree will be passed against you, and that will be recovered. There is no further trial. So this is a very landmark judgment, Dayavati versus Yogesh Kumar. This, once the mediation, and another option is available under section 147 of the negotiable instrument, that is also after amendment has been added, section 147, that is the compounding of the offences. That is the compounding of the offences. This is complaint under section 138 is compoundable offence. It may be compounded. Once any person feels that yes, at any stage of the trial, that we can move an application on the very first date of the hearing, even you can move an application for the compound under section 147 of the negotiable instrument. Yes, I want to compound this offence, then this offence may be compounded. I will also show the judgment of the compounding, the landmark judgment of the Honorable Supreme Court. Damodar S. Prabhu. The Honorable Supreme Court, this is landmark judgment of the Honorable Supreme Court, each and everywhere it is quoted and mentioned. Once you will also receive the summons, this judgment has been mentioned that once you want to settle the matter, approach to the court and move an application for the compounding. Damodar S. Prabhu versus Sayyid Babalal H. Respondent. This case was decided in 2010. Relevant para, whatever the guidelines has been given by the Honorable Supreme Court. This is the guideline. The guideline, the circumstances, it is proposed as follows, that directions can be given that the writ of the summons be suitably modified, making clear to the accused that he could make an application for the compounding of the offence at the first or the second hearing of the case. And if such an application is made, compounding may be allowed by the court without imposing any cost on the accused. There is no cost, whatever the check amount, you can move an application. Yes, my lord, I want to make the payment, entire payment of the check amount. You can only pay the check amount. There is no cost, no interest, nothing else. First or second date of the hearing. Once you are not moving an application on the first and second date of hearing, then further you can move an application. If the accused doesn't make an application for the compounding offence, then if an application for the compounding is before the magistrate at a subsequent stage, in any stage, compounding can be allowed subject to the condition that the accused will be required to pay 10% of the check amount to be deposited as a condition for the compounding with the legal service authority or such authority as the court may deem fit. This is the 10% of the total check amount. Once, even though you didn't move an application, and you can also move an application in the subsequent stage. Similarly, if the application for the compounding is made before the session court or a high court or a revision or an appeal, may not trial is over. Trial is over before the learned MM. You can go to the appeal. In the appeal, you can also move an application. Even if you go to appeal for the high court, then you can also move an application. Allowed the condition that the accused pay 15% of the check amount. Then in that condition, you have to pay 15% of the check amount. And finally, even though you are not satisfied and go to the Supreme Court for appeal, even you can also move an application for the compounding. It may be before the Supreme Court, the figure would be increased to 20% of the check amount. Then you can pay 20% of the check amount. This is a very landmark judgment has been passed by the Honorable Supreme Court, and this is the best. On this judgment, Honorable Court are being issued the guidelines that yes, once the summon has been issued under Section 138 NI Act, then it is always contained these provisions. And I'd like to also share with you that Section 143A, that is interim compensation, it has only effect of prospective effect. It is only have a prospective effect. It is also decided by the Honorable Supreme Court in the matter of the G.J. Raja versus Tej Raj Surana. In this matter, G.J. Raja versus Tej Raj Surana, the Honorable Supreme Court says 143A has only the prospective effect, not the retrospective effect. And the amendment in Section 148 of the NI Act that says, yes, once we go to the appeal, the Honorable Court may award minimum 20% of the check amount that may be from the retrospective effect. So therefore, my learned friend, I would like to cover the entire things, whatever I can do my best. And even though if any query, any questions, then one by one, my learned friend may ask. My learned friend may switch on your videos, and then you can discuss face to face. Please switch on all your videos. Wonderful listeners, beauty faces.
Good afternoon, all of you. Good afternoon, sir.
Good afternoon. Good afternoon.
So first of all, that we are very, very grateful to Nitya sir for organizing this knowledge-oriented webinar, and in very precise and very concise manner. I was listening from it. Sir, from the inception, and more important, which is the second part of it, that I'm very delightful because all the participants today were listening this topic very carefully, very silently. This is the important part of the entire thing. And secondly, I'm very delightful to be in touch with all my colleagues that I know personally, professionally, and this is also the medium that we are together. So that is, and the credit goes to you, Sir Nitya sir, and thank you so much, sir.
Thank you. Thanks a lot. Thanks a lot for joining and presence sharing. And of course, it is always enjoyable to share my knowledge, whatever I have. I try my level best, certainly to young boys and girls who want to come into the practice, because most of the students is never prefer to come into practice nowadays. They want to go for the corporates. So I'll always welcome to the new generation to come in the practice, because it is one of the most enjoyable moment. And of course, it is always give a pleasure to share the knowledge with everyone. Of course, this profession pays a lot to everyone, but yeah, yes, certain time you have to devote.
Yes.
Thank you. Thank you for your very kind words. Yes, please switch on your all videos, please. All the participants, switch on your videos. If all the participants are listening, please switch on your videos.
Good afternoon, sir.
Good afternoon, ji.
Sir, actually, I have a small question for you.
Yes, sir, please.
But first of all, I would like to thank you for such an informative session.
Thank you.
So, sir, the question is, as you said in the beginning only, that we have 30 days time period from the day of the return memo
Yes,
to serve the legal notice to the accused.
please.
But what if that 30 days time period is over? So, what can we do about it?
Once the 30 days period is
Over, and we didn't serve the legal notice.
yes. Once the 30 days period is over, you didn't serve the legal notice, then you have to present the check again.
Okay, sir.
You have to present the check again, and once we will again receive the bank memo, fresh bank memo. There is no restriction on the presentation of the check. You can present the check any times. Then you have to present the check again, and again you will receive the bank memo, and bank memo have a fresh date. Then you can serve the notice from 30 days from that fresh bank memo date.
Thank you so much.
Thank you. Thank you for a beautiful question. Yes, please.
I think all the query already has been sorted out by you, sir, during the course of the. I don't think that anyone has.
सत्य प्रकाश जी, if you want to ask, आप अपना वीडियो तो खोल लीजिए.
At least open the video. Let us see each other, the face of each other, so that we can remember the past days.
Yes, sir.
And use it as a medium to be connect. Use it as a medium, professionally connect, personally connect, because ultimately this is the profession who needs the contacts with everyone.
शैलजा सिंह जी, आप वीडियो तो ऑन करिए, कम से कम हम देख तो लें आपको इतने दिनों के बाद.
And that is the beauty of this profession. In the meantime, sir, I came up with a question that I was handling a matter.
Please.
And I went to the revision court to the 30,000. So yesterday the matter was, the judgment was delivered, and both revision petitions are allowed, which we have filed. But the very important issue involved in that was that a company secretary, the practicing company secretary, I'm saying it because of the practicing company secretary, that there is a form, DIR 12. Earlier it was 32, but now it become 12. And the difficulty was that there is a column, a particular column in which says that you belongs to what category, promoter or non-promoter. So what was happening in that matter, that the promoter, the category practicing company secretary mentioned that the category of the candidate is the promoter. As a non-executive director, additional director. Promoter, non-executive, additional. So what was the difficulty for me to argue the matter before the session court is that I was the promoter, sorry, I was not the promoter. As a matter of fact, I was the additional director only in terms of section 161 of the Companies Act, and the independent directors. There's a very judgments, almost 32 judgments over the same issue. SMC judgment is the parent judgment on this, which says that the person, the complainant, who is fastening the criminal litigation against the accused person must mention the very specific attribution against the accused person.
Please.
Very, very specific.
Very specific.
Very specific. And suppose you are naming some person into the complaint or the legal notice itself, there must be a very specific attribution against the person.
Yes, of course.
If the person is the accused is managing director, then you no need to mention the specific attribution. If the person is the whole-time director, again you no need to mention the specific attribution in the role defined. But if it comes to the another person, additional director, non-executive director, or the other directors, that you have to mention the specific allegation, role performed, as to whether, main point is as to whether that they were managing the affairs of the company, day-to-day affairs of the company or not. So on that sole point, we went to the revision court, and both revisions are allowed on the very same point.
You were appearing on behalf of
one of the accused.
One of the accused, yes.
One of the accused was the additional director, but the category was promoter as per the DIR 12.
What the learned trial court issued summons against you?
Yes.
And you have a challenge that there should be no
before the revision court.
Yes.
The revision court, and both the revisions are admitted.
Okay, both the revisions are allowed. That this summons has not been properly being
issued.
Properly
issued, because there is judgment in the matter that I think the SMC is the parent judgment, in which there is a duty upon the MM.
Yes.
The duty upon the MM that how to deal with a complaint.
Yes.
There's a various paragraphs in the judgment itself is there that the MM should be very careful when issuing the summons to the accused person.
Yes. All the directors cannot be party, especially in the criminal cases. Yes.
Cannot be the party, and that is the very, very discussing judgment that which is very well discussed by the Dheeraj Modke court 350, and he mentioned this point very well that the category is the promoter. But again, it becomes the matter of trial.
Yes.
Non-executive director, I hope I'm not taking much time.
No, not an issue. Not an issue.
If the director is the non-executive director, the additional director, but the document shows that you are the promoter also. But as a matter of fact, I was not the promoter. I was not performing the.
Yes, being a company secretary, how can we be the promoter?
Right.
Because we are not the managing director, not the whole-time director.
No,
we cannot be the promoter.
No, sir. I was saying that mistake was made by the practicing company secretary who filed the DR12.
Yes. That mistakes have been made.
That mistake has been made. So because of that mistake, it could be very, very painful for me that the matter could be referred to the trial court by saying that is the matter can only be dealt by the trial court, that you were the promoter or not. It becomes the trial court matter then. But the honorable session judge simply goes on the point that of course you are the non-executive director and the independent director, though you cannot be the promoter of the company.
Yes, of course.
Very, very a very short span of time for the hardly for 6 months. Both the reasons are allowed in matter.
Congratulations.
It was wonderful experience.
Yes. Once you will win the case before the court,
I know
of course, it is always enjoyable moment.
Right, and because I have also filed the 42 before the High Court on the check bounce matters in which the limitation issue arise. Maybe I don't know how the High Court will deal with this issue. This is yet to see.
No, that order has been challenged before the High Court.
No, that is not challenged. That is the order of yesterday.
Okay.
In another matter, I went to the High Court. High Court issued the notice and exempted me from the appearance before the trial court.
That is question.
That in question.
482 question. Normally our experience is that once we will go to the High Court, normally in the High Court issue notice and exempted the persons to be appeared before the trial court. And sometimes at the end, once the matter is finally argued, it is being quashed. Because Supreme Court is very clear that once he is not the signatory of the check, he is not involved in the day-to-day affairs of the company, he cannot be the party. The summons, if it is issued, it is illegally issued and it has to be quashed. Only the director, who is the whole-time director, if there are only 2 directors in the company, of course, both will be liable for that. If it is more than 2 directors, then you have to look into who is the executive, who is the non-executives. Once non-executive independent directors, of course, questioning will be there.
Right, sir. And that is the duty. I think the learned MM should be very conscious about it. That to whom because ultimately
while issuing summons, learned trial court doesn't go into that who is the memo of the party sometimes and issue summons to all the accused. Simply say issue summons to all the accused. Who is all the accused? They never go through that sometimes.
And it has very bad repercussion because ultimately the other accused, other than the whole-time director, the major, they will be going to some of them will be going to the revision court, some of them will be going to the 482 to the High Court.
Yes, of course. He has to approach because without any fault, he is being a party and unnecessary. He has to face the trial. He has to appear before the court in each and every date. Once he will not appear, then the bailable non-warrant warrant issue against him, and the police will go to his or her home. It is very bad impression.
I hope the other participants also enjoying this conversation. If they have any question, then they can share with Nitya sir over the point zone.
Good afternoon, sir.
Good afternoon.
Sir, my question is, once the
may I know your good name, please?
Sir, my name is Ashutosh.
Yes, sir, please. Switch on that video, please.
Yes. So once the adjudication is done under section 138,
yes,
can we file a separate money recovery suit to recover the check amount? Because in our
case, of course, there is a provision under section order 37 CPC. You can file a civil because under section 138 there is no recovery of the amount, maybe the punishment.
Because
but
again,
for the recovery of the amount, you can approach to the civil court under order 37 CPC. That is confirmed date. Once the check has been issued, it is deemed that there is a confirmed date, and under the confirmed date, you can file a case for the recovery under order 37 CPC.
So section 13 of CPC.
Order 37. Order 37 CPC, not section.
No, there is some provision of res judicata.
No,
in
no, no.
CPC.
There
So this
that
will
is no,
not
no.
trigger
There is no
in the,
provision of the res judicata. Of course, there is a provision of res judicata, but res judicata will not applicable here, because once there is a 138, that is the criminal proceedings, and once go for the recovery, that is the civil proceedings. In there are the remedies available in the both the criminal as well as civil. There is no effect of the res judicata. Likewise, suppose if you are filing a complaint before consumer, you can also go for the NCLT, you can also go for the RERA. There is a different remedy available to you. And once you will go for the criminal, that is the criminal side is something different and civil side is something different. You can, under section 138, there is no procedure for the recovery of the amount. Once you want to recover the amount, then you have to go for the civil court for recovery of amount. Both are the separate legal actions, and both complaint are maintainable.
Whether if Ashutosh ji, if you go to the section 10 or 11 of CPC, I guess in which the res judicata is defined, I guess section 10 or 11, I guess, of CPC. If you will be filing the same application before the civil court could be the other court with the same prayer, then the res judicata will be applicable. So the main thing, you have to see the prayer you seeking, but the criminal litigation is completely different. It does not apply here.
thank you. Because in criminal pleading, we also shout for a recovery of check amount.
Prayer A will be the punish to the accused, and the B will be the recovery. That is the well settled into the 138 itself.
Thank you.
Sir, I want to ask a single question. Hello, sir.
Yes, Mr. May, sorry.
Sir, I want to ask a single question. Sir, what if the accused refuses the legal notice?
Please come again.
Sir, what happens if the accused refuses the legal notice?
Okay. Once you have served the legal notice, complainant has served the legal notice, and the accused did not receive, and say that yes, if in the envelope the accused say refused, and the person who has gone to deliver that notice and write on that envelope that it is refused, then it is deemed to be service. You cannot refuse to accept a notice. Once you have refused it, then it will be deemed to be service. Court will consider it, yes, it has been served.
And sir, I guess the whole background of it, that deemed service comes from the origin that you attempted to serve the notice.
Yes. It is deemed to be delivered.
Then
because once someone go to deliver the service and didn't accept the notice, then how it can be delivered? Then it is a provision that yes, there is a refused written in the envelope. Yes, it will be deemed to be service. Yes, any question, please, anyone?
Any question, whether related to the subject or the other subject? You want to get benefited from the other aspects also, if anybody want to discuss.
Yes, of course, no, whatever the knowledge I have, certainly I will share.
We are welcoming from the other spectrum.
Probably
whether it is secretarial, whether it is legal. If Nitya sir allows it, definitely
yeah.
the whole
Yes, of course, certainly, whatever the knowledge I have, certainly I will try to give my insight. But certainly, once I'm not aware, certainly I will go and research it, then I will answer the question. No issue.
Or I would say the other participants also can share some experience if any time they had it in their professional or personal career. Whether it is secretarial, whether it is legal, whether it is criminal or civil.
Man Singh ji,
please. Man Singh ji is senior member of Man Singh ji.
Man Singh ji is CA, CS, ICWA advocate, and all those having a lot of degree.
Karthika Tripathi is also not participating. I'm going to complain everyone now. If you're not participating, I'm going to complain everyone individually. Miss Advocate Shalja Singh. At least respond.
Okay, thanks, friends. Thanks for your session sharing. Probably there is no question at all. Then we will end
Yes.
the session. And certainly we will meet again on the fourth Saturday with some new topics.
Thank
If
you,
any
sir.
of if
Thank you so
any
much, sir.
any one of our friends wants to deliver something on this platform, they are also most welcome. But he can intimate me in a week advance that yes, I want to deliver something on that particular issue. If Deepak, if you want to say something on any subject matter, whatever you think that I have the command on that subject, certainly you are most welcome.
But I was
Any,
thinking we must have a webinar on the IBC also, IBC provisions also.
yes, yes.
Whether
Yeah.
we can, it could be limited to section 7, section 9, non-corporation, and any other, because it would be very difficult to cover all the entire IBC, but we can pick or select a particular issue on which we can discuss upon.
Certainly, we will think over, and certainly because one of my associate, senior associate, Ms. Preeti, she has qualified the IBC exam, and she has the in-depth knowledge of that subject matter, and certainly she will take the session. Maybe the next session or maybe next session, but certainly she will prepare, and we will take care of, and certainly she will take the session.
Thank you so much, sir.
Thank you. Thank you to all of you. Namaskar.